Law of guardianship under Muslim law. Guardianship is the lawful entitlement to supervise the movements and acts of a person who is unable to care for himself and handle his own affairs due to mental flaws such as an infant, an imbecile, or a lunatic. It includes the ward's custody as well as the authority to deal with the ward's possession. Meaning of guardianship. The term guardianship, vilayat, connotes the guardianship of a minor. According to Section 3 of the Indian Majority Act 1875, someone domiciled in the Republic of India who is below the age of 18 years is a minor. A minor is assumed to have no capacity to protect his or her own interest. Law thus requires that some adult person must safeguard the minor's person or property and do everything on his or her behalf because such a minor is legally incompetent. A person who is authorized underneath the law to guard the person or property of a minor is called a guardian. Under Muslim law, guardians are needed for the aim of a wedding, for protecting the minor's person, and for protecting the minor's property. Guardianship under Muslim law. Guardianship under Muslim law is known as hizanat. Guardianship and hizanat are often misinterpreted to mean the same thing. However, under Islamic law, these two components of guardianships are distinct and are governed by separate laws. A child's guardianship entails overall responsibility for the child throughout his or her childhood in the unavailability of the father or his executor. The minor's natural guardian, the paternal grandpa, is in control of the minor's person. On the other hand, custody of the child merely refers to the child's actual possession, custody at a given age. Despite the fact that mother is not the child's natural guardian under Muslim law, she has a claim to custody of the child until the child reaches a certain age. It is often referred as hizanat, which connotes the right of a mother over her children. The father or the paternal grandpa, on the other hand, has entire power over the minor for the duration of the minority. Kinds of guardian: a natural guardian or a legal guardian, a testamentary guardian, guardian appointed by courts or statutory guardian, de facto guardian. Fizuli is out of wage in modern Muslim law. Legal or natural guardianship. A natural guardian has the authority to control and monitor the work of a minor under all schools of Muslim law. The father is acknowledged as the natural guardian of his child. A legal guardian is also known as natural guardian. However, in the absence of the father, the executor of the father's will may act as a legal guardian. The executor could be a person named by the father or grandpa to function as the guardian for his minor child. Therefore, the natural guardian of a minor in order of priority are as follows: father, executor of father, paternal grandfather, the executor of paternal grandfather. Under Muslim law, within the absence of any of the above mentioned persons, no one else can be recognized as the natural guardian of a minor. Shia law, within the absence of father only, paternal grandfather could act as a legal guardian. In the presence of paternal grandfather, the father executor has no right to act as legal guardian of a child. Can the mother act as a guardian or be appointed as guardian of the minor? Mother can neither act as a guardian nor be appointed as a guardian under Muslim law. In the case of Ghulam Hussaini Kutubuddin Maner versus Rashid Abdul Razak Maner, the Supreme Court held that a mother of a minor cannot be appointed as guardian to accept the gift on his behalf during the lifetime of the minor's father. Testamentary guardian. A testamentary guardian may be one that is appointed as a guardian of a minor beneath a will. Only a father or in his absence paternal grandfather has the right to appoint a testamentary guardian. A non-Muslim and a feminine might also be appointed as a testamentary guardian. In the case of Atika Begum versus Muhammad Ibrahim 1912, the Allahabad High Court held that in the presence of a father, the grandfather has no right to appoint a guardian for a minor. Shia law. A non-Muslim cannot be chosen as a testamentary guardians appointed by the court. In the absence of a natural or legal document guardian, the court has the power to appoint a guardian for the minor's person, property, or both. The Guardianship and Wars Act 1890 governs the court's appointment of a guardian and it applies to all Indians regardless of religion. The district court is given the authority to appoint or declare anyone as a guardian under this statute. The district court may designate any individual as the guardian of the minor and his property whenever it deems it necessary for the minor's welfare, taking into account the child's age, sex, and wishes. De facto guardian. A person who is neither a legal guardian nor a guardian appointed by the court but has voluntarily placed himself in the charge of the person and property of the minor is known as de facto guardian. A de facto guardian is a mere custodian of the minor's person and property but has no right over either. Disqualification of a guardianship of person. In case of mother and other female relation, if she married a person who is not related to the child within the prohibited degrees by consanguinity, if she leads an immoral life, if she resides during the subsistence of marriage at a distance from the father's place of residence, if she converts to another religion. In case of a male, if a minor is an unmarried girl and is not related to him within the prohibited degrees, if a non-agnate within the prohibited degrees, such as maternal uncle is available, he should be preferred over an agnate person who is descended from the same male relation, not within the prohibited degrees. The object of this Islamic rule is to avoid the custody of a male hazin who may marry the girl. However, this rule is not recognized by the Shias. In case of a husband, if the minor wife has attained the age of puberty or is not of such an age to allow consummation of marriage, cessation of the authority of guardian by death, removal or discharge by the court of wards assuming superintendence of the person of the ward, by the ward ceasing to be minor. In the case of a female ward, by her marriage to husband who is not unfit to be guardian of her person. In the case of a ward whose father was unfit to be the guardian of the person of the ward, by the father ceasing to be so. The powers of the guardian of property cease by his death, removal or discharge. By the courts of wards assuming superintendence of the property of the wards, by the ward ceasing to be minor.